and welcome to this episode of the That's So Hindu podcast. I am Needhy Shah, Legal Director for the Hindu American Foundation, and today's guest is Akanksha Kalra, an experienced immigration attorney who's based in Philadelphia, Pennsylvania. Akanksha advises individuals and businesses throughout the country on immigration and nationality matters, and she regularly practices before federal agencies and immigration courts. Please note that Akanksha will only be offering insight on immigration policies, relying on her expertise in the field, and any answers or information she shares are not legal advice. You should hire an immigration attorney to assist you with any personal concerns. Welcome to the podcast, Akanksha. We're so excited to have you.
Thank you for inviting me, Needhy. And also thanks to HAF for all the work that you're doing through these podcasts and seminars for the community and to provide clear information about recent immigration changes. I'm glad to be part of that today, and namaste to everybody.
Yes, it is very exciting. All eyes are on immigration under the Trump administration. So today we're going to delve into some of the immigration issues that are top of mind for our community. Many of them are immigrants themselves, and they have friends or family who are immigrants. So we're going to discuss the immigration-related policy changes that have happened in the past 8 months and how those changes are impacting people in their daily lives. And it'll also give us a sense of what has changed and what hasn't changed. So one of the biggest stories that came out day one of the Trump administration is Executive Order 14160, which is, the one related to birthright citizenship. And under that order, a newborn would only have U.S. citizenship granted when they are born in the U.S. if either their mother or father was a lawful permanent resident, which is a green card holder, or a U.S. citizen. The Trump administration says they're going to follow through on this policy, but courts have stopped them from letting it take place because it was challenged in court immediately, and it is still blocked from taking effect. So this legal battle continues. And I think we're going to see it in the Supreme Court again. Akanksha, do you think this is going to affect immigration, particularly temporary visas like employment-based ones that are held by a large part of our community?
Okay, so first of all, the the executive order about birthright citizenship right now is there. It exists, but it's on pause. So right now, to answer your question, would it affect employment-based immigration? Well, any child who is born here right now to parents who are on a non-immigrant visa, such as an H-1B, or let's say if the mother is on an F-1 student visa status, the baby will still get U.S. citizenship like before. However, all of the debate, all of the news headlines around this whole thing definitely has created anxiety and a lot of apprehension and uncertainty. So families who are in the situation, who are either, expecting a child or planning to have a child, they are asking questions about should that be any issues related to the timing of the child's birth or what other steps they should take, etc. Yes, they are being impacted.
Yeah, that makes a lot of sense. And for the folks who are asking those questions, are there any steps that you can practically take to plan? There's a lot of uncertainty, but is there anything that, our community can think about when they're planning immigration, they're planning kids?
Mm-hmm. So any steps that one can take? Unfortunately, there is no such, checklist of steps or guidance to give them. In fact, I have been getting asked this question from clients or potential clients who want to schedule a consultation. Someone asked me recently, hey, this was their exact question. There are rumors that some states are not issuing citizenship documents to newborns after February 2025 because of this executive order. Is that true? Well, the standard response is right now it's status quo. The way the current system works right now, when a child is born, the hospital collects the baby's details and the mother's. Typically, it's the mother's, but the father's information also. Sometimes the basic information is collected, the name, date of birth, address, etc. And then the hospital just sends it to the state where the child is born to the state's Vital Records Office. It's called sometimes the Office of Vital Statistics. It could be the Department of Health. It could be the Registrar of Births, depending upon the state. The state is the one that issues the official birth certificate. Hospitals right now have no such system in place. They don't ask, nor do they report the parents' immigration status. So, what practical steps can we tell any people who ask those questions to take? I can't tell you about the practical step, but just practical advice. Don't give in to rumors. People sometimes say, hey, I saw something on some blog or some report that even if the executive order right now is on pause, the child cannot get a social security number issued or a passport issued. I don't know. My answer is I'm not going to comment on unverified reports, right? I cannot. What I can tell you is on the USCIS website, there is an announcement that they have posted about that they are ready to go and start implementing this executive order as and when courts issue it. But how they will implement it, there is no guidance available on that at this point. So the chill factor is there among the immigrants, even though there is no legal change right now about birthright citizenship. But again, that's the effect of news cycles, right? Headlines create fear and they do create apprehension. And yes, it's there.
Right. Yeah, I think that that's an important distinction to make, that there's headlines and rumors, but then there's actually what's happening kind of in the legal system, and what we're seeing even in, the Trump administration. They are not able to implement this yet. So don't rely on unverified rumors, keep sticking with the actual process that's there.
That is correct.
That's great. So that's really helpful. And that leads us more on the topic of temporary visas, right? There are many different types of temporary visas that folks are here on. One example that you already talked about is F1 student visas. So one news story that came out earlier this year was Priya Saxena, who was completing her PhD on an F1 student visa. And in April 2025, her visa was suddenly revoked for criminal records related to a traffic ticket from 2021. And then Priya was able to go to court, get an injunction. She finished up her PhD and graduated in May of this year. Now, again, F1 student visas, temporary status, you're here to study. But there are thousands of international students who are here who have seen issues with visa revocations for a wide range of traffic or, activism related infractions, whatever it is. And it seems like the legal challenges were mounting there. So that was last semester. And now we're in a whole new academic calendar year and semester. And there's going to be new students who are facing issues or concerns. So what are your thoughts around some of the changes that have come out that are affecting students that are here from international countries and studying temporarily?
Okay, so I'm not going to be able to comment on any particular case as such that was reported, but just generally, broadly speaking, I think first thing that we need to make sure is your audience understands there is a distinction between a visa and the person's immigration status. They're two different things, right? They're tied together, but they are not the same. News reports or reporters sometimes kind of use the two interchangeably, but that's not the case, okay? The visa is literally a stamp in your passport that is issued by the Department of State. The Department of State has jurisdiction over all of the US consulates and embassies worldwide. That's where a person applies for an actual visa to come to the United States. So in this particular case, since we're talking about F1 visas, they would be coming on. They would be coming with an F1 visa in their passport. Once they are, or even to apply for admission at a port of entry into the United States to be what we call admitted in F1 status, they would have to present some other documents in addition to the visa, such as their I-20, which is a document their university or school issues them. Okay, so to make it more clear, let's go back to a little bit to the background of how these departments were created. The Department of State has been there from before, but before 9/11, immigration was, all of the powers of immigration were pretty much vested in one agency for most of the 20th century. That was the Immigration and Naturalization Services, INS. That's what it was called. And I've been doing this for more than 27 years. I dated myself. But when I first started doing immigration, anything to do with immigration was with INS. I'm an immigrant myself. When I went through the immigration process myself, it was also through the INS. All of this changed post 9/11. Now, after 9/11, or rather, 9/11 happened in 2001. In 2003, a whole new department was created, which is called the Department of Homeland Security. So the immigration functions that were with the legacy INS were now split into three different agencies. One is the U.S. Citizenship and Immigration Services, USCIS. The other is the enforcement wing of immigration, which is ICE, Immigration and Customs Enforcement. And the third is the CBP, Customs and Border Protection. Those are the immigration officers, officials that we see at airports and border crossings. So State Department has kept its old role, which is issuance of visas abroad. Once you land in the US, you are under now the jurisdiction of the Department of Homeland Security. The Department of Homeland Security is what controls your status. And in the case of an F1 student, another program that they have to adhere to with the rules of is called SEVP, Students and Exchange Visitors Program. Now, the SEVP shares its information on each foreign student with the Department of State, the Department of Homeland Security, and also the university or school where the student is enrolled. And the students, F1 students, SEVIS record, Student Exchange Visitor Information System, that's the database managed by the SEVP, which manages all the information related to the SEVIS program, as to the international students' status in the US. So if somebody has an infraction or something which jeopardizes, let's say, their status while they're here in the US, the International Students Office at their university or school will update or make that notation in their SEVIS record. So what sometimes the news headlines are referring to, that these students' visas were revoked. Well, if they are in the US, then probably what they mean is their status was reported as violated or some non-compliance with that. And that can be fixed. There is something called a reinstatement of status as well. That can be done. So now what has happened in the last 8-9 months is the law hasn't changed, but the tempo has. The reporting of violations, that has increased, and the scrutiny has increased. What has also increased at the Department of State level is the higher scrutiny over the issuance of these F1 visas to foreign students. And if they are already in the US, Department of Homeland Security is now enforcing status rules more aggressively. So to the student, it feels like it's one big hammer coming down, but it's two different agencies often acting in parallel.
Yeah, that's really helpful, because there's a level of just, understanding the process that you can only gain by having experience with it, and a lot of experience. And that's a really helpful explanation. But I think it really comes down to what options do students have if they're here to study and then they have a record of violation, whether it's civil or criminal. The concern is, what do you do when something goes wrong, even if it's, a traffic violation?
So to answer your question, I mean, they just have to be more careful, because the margins for error that were there before, definitely they have shrunk. So even things like minor violations, administrative mistakes, a paperwork slip or two, this can now ripple into bigger immigration consequences. So, to go back to the question about if the person was let's talk about a scenario where a DUI violation is there, right? Believe it or not, in the Indian community, I've been doing this for many decades now, DUI is more common than you would think. The student activism and participation in protests, etc., or First Amendment speech, whatever, those are more recent. Social media is, okay, not as recent as this protest, but definitely, maybe in the last 8, 10 years. But DUI has been there before. Another one that has also been there for a while, and we see it all the time, is shoplifting. Mm-hmm. So DUI, shoplifting, fairly common among students. In the past, first time DUI might have just meant, fines, going through it at your local, within the local court system. Sometimes the judges would let them do something like ARD, some rehabilitation, whatever they call it, or maybe suspend their license. But at the local, maybe at the state level, it didn't necessarily always trigger immigration action. It could come up at the time if they have to go out and apply for another visa, or when they're applying for their green card at a later stage, they have to then disclose it. But this was not something in all the years that I've been doing this. Minor DUI and shoplifting typically would not end up revoking that person's visa or preventing them from getting a green card, as long as everything was truthfully disclosed and all of the court certified records related to that offense were submitted to immigration. They would still go ahead and approve the case. Now it's a different scenario. The consequences are bigger. They're showing up faster. We have now been hearing reports about DUIs can prompt visa revocation or a status violation while the student is still in the US, which may lead then the Department of Homeland Security to question whether they are going to continue their status. So as I was saying, shoplifting, another example, even small dollar amounts. I had a case once where it was a shoplifting offense. This person says she really actually was not aware. It was for a pair of socks for $3.99, $3 and less than $4. And she said she didn't realize, but it was in her coat pocket or whatever. They still caught it. But these kind of things, when happened, usually did not, snowball into something bigger. Now it could. The potential definitely is there.
Yeah. So it sounds like there's a small margin of error, whether it's a mistake or intentional. Yes. You're jeopardizing a lot more than the criminal or civil process if you're here with an F1 visa and you end up in a situation where there's a violation.
Correct. And also because schools are now reporting it more often. Wow. So that has also changed.
That's really helpful. So if you're seeing that there's a thin margin of error, are we seeing deportations targeting students who are here from, the international students?
The deportation process is not that easy or straightforward. I don't know of any instance where a student would just be deported for having a DUI or a shoplifting violation. But if that, in combination with other things in his or her record, could then lead to that person being placed in deportation. Now, deportation is the actual act of when the person is sent back or sent to another country. Legally, the term we use for them is the removal process. So when a person has had a status violation or has otherwise done something which would place them in removal proceedings, they would then get what you call an NTA, a notice to appear before an immigration judge and explain their case. So yes, I have had some colleagues report on on our list that they are getting to see NTAs being issued for status violations, whether it's for an F1 or maybe for an H1B worker, because they have lost their status for one reason or the other. But they would not just come pick you up and deport you because you had a minor DUI violation. You would still have to go through the legal process of getting that done. But yes, that can happen.
Okay, that's really helpful. And are there any other trends that we're seeing impacting students who are coming here for the new school year or who might be thinking about applying to come here, come study in the US starting next year, let's say?
Yeah, so there have been some recent changes, and one of the big ones that's going to impact the F1 students is something that was announced by Immigration on literally August 27, 2025. They proposed a new rule, which is, the government wants to replace something which is called the durational status with a fixed expiration date for the time the person is going to be admitted. So again, without sounding too esoteric about this, basically what it means is, okay, so any person who comes to the US on any kind of visa, let's take, for example, a tourist visa, a B1 business visitor, or a B2, what we call tourism, or somebody who wants to come to the US to visit family or for tourism purposes or any other, they usually can get a multiple entry 10-year visa. Okay. An H-1B visa is typically issued for up to 3 years. All visas are typically issued for a finite period of time. But as I said earlier, a visa is different than the status that the person is here in the US. So going back to the example of the tourist visa, even if I have a 10-year tourist visa in my passport, I cannot come and stay in the United States for 10 years at a time. What that means is I can travel back and forth to the United States, and for up to 10 years, or for the duration of the validity of that visa, I don't have to go and renew my visa. But each time I come to the US and am questioned by a CBP official at the port of entry, they're going to ask me what the purpose of my visit is. And then they are going to, what we call, quote unquote, admit me into the US. And each person who is admitted into the US, their information is recorded, their biometrics are taken, and they are admitted for a finite period of time. So in the tourist visa case, typically for them, they will be admitted in for any stay is no longer than 6 months. So it'll be 6 months or less that they are admitted in. An H-1B typically will be admitted in for a period not exceeding 3 years, whatever is, it's on their approval notice, not going to a different category. But for an F1 student, the visa that they have in their passport is typically issued for 5 years. However, when they come to the United States and they come to the port of entry and they are admitted in F1 status, their I-94 arrival departure record will have a notation which is called D as in David, /S, S as in Sam, duration of status. So what that means is you are admitted to the United States to study, and we will allow you to stay here up to the duration of your status. So what that means is, as long as you follow the rules of F1, you are enrolled in a full-time course of study at an accredited school or college. You keep your I-20 and your CVIS record updated, then you can stay here, and your stay here is valid for as long it takes for you to complete your studies. That there is no end date that they stamp on the passport or on the I-94. This change that is coming, that was announced in August, end of August, government is saying that we are going to replace the D/S with a fixed expiration date on the I-94, which will be tied to the end date of your program. So if you're coming for a master's program for 1 year or 2 years, you will only be admitted up until the time you're enrolled in that program. And the cap for that, if you're coming, let's say, for an undergrad, is a maximum of 4 years. Which means that the F1 students who are now going to be admitted once this rule goes into effect, will not have D/S on their I-94. It'll be a fixed end date, which means if their studies go further than the end date that's on their I-94, they're going to have to file an extension with the immigration. So not only are we going to see tougher enforcement, not only are we already seeing fewer visas being issued at the consulates for a whole slew of other reasons, we can talk about that. Now, with this new rule going into effect, as and when it does, CVIS terminations are going to get more. Visa revocations or status violations for things are increasing already. with this new change about D/S/S, this is going to be a big one for incoming F1 students.
That's really helpful because I know that we've talked previously that sometimes students who are here may overstay, right, the date on their visa or whatever that time frame is because it's unclear, or they haven't thought about it and there's no finite date. It seems like whether that's intentional or unintentional, it's going to be much clearer what the date that they have to depart after their F1 visa is valid, until that's going to become much more clear for everyone.
One would think, but again, what is this going to mean for people who are planning to come in right now? Again, the fear, the uncertainty, and the apprehension of that already is there before you come here, and once you come here, then for keeping up with all of this.
Yeah. Yeah. And, it's not just students, right? Because we're getting into the end of the year and we're going to see students, we're going to see families, people are traveling abroad, people are coming in from abroad to visit on all types of different visas, on all types of, for all types of different reasons. And so one major change that happened again this month, just a few weeks ago, was starting September 2nd, the non-immigrant visa applicants of any age will have to appear for an in-person interview. Can you talk about that requirement? Because that's also a significant departure.
Yeah, so going back to what I was saying earlier, the visas are issued by the Department of State at the US consulates and embassies worldwide. So another big change that went into effect, that's already in effect starting September 2nd, is every non-immigrant visa applicant. By non-immigrant visa applications or applicants, we have the whole alphabet soup of visas, starting from A all the way to SGUV. But the main ones that are, especially for the Indian American community that are relevant are B1, B2, tourist visas, business visitor visas, F1s, H1Bs, L1s, O1s, P visas, etc., J1s. So any person that had to apply before September 2nd, if they already had a valid visa in their passport and they were only going to be applying for renewing their visa, there was something called the consulates followed what was called the interview waiver program. So under the interview waiver program, they did not require some applicants, for example, children under the age of 14 or seniors, or often people renewing their visas, to come again for an in-person interview at the consulate. You could just, if you're renewing a visa in the same category, and if it had expired less than 48 months ago, you could just mail in your passport or use a Dropbox. Starting September 2nd, every non-immigrant visa applicant, regardless of age, has to now appear in person at a US consulate for an interview, even if they are just renewing a visa. So that is now a huge shift. What is it going to mean practically for the consulates? More volume, longer wait times, no more mail-in or Dropbox renewals. So to go back to what you were saying, so for example, if you have a family member who's coming from India to the United States to, let's say, attend a wedding, or for dropping off their kid to school, or typically in spring and summer, they come for attending graduations or vacation or visiting family members, or Christmas time, people go back and forth. If they now have to apply for a visa in order to come back, whether it's a renewal or a first time issuance, this is going to mean more delays. So they're going to have to start preparing for it accordingly. And of course, the heightened scrutiny still is there.
Yeah. And I wonder how that works for people who are physically in the US, right, on whatever visa they have. Are they going to have to go back to their country of origin and get the approval there, or are there going to be other ways that they can finish that process?
Yeah. So again, going back to what I was explaining earlier, there is a difference between the visa and the status. Once you are in the United States, let's take the example of an F1. As I said earlier, the F1 visa typically is issued for 5 years. And let's say you are someone who came to do your undergrad here. Following your undergrad, you either did your optional practical training, or let's say you now have enrolled in a master's program, or you have now changed your status to an H-1B. So the F1 visa in your passport has expired. Or let's say, forget the H-1B, that's a little different. Let's say you are an F1 student, still an F1 student. Your CVIS record still shows you as an F1 student, but the actual visa stamp in your passport has expired. Does that mean you are illegally here or unlawfully present in the US? The answer is no, because the visa is just a travel document that allows you to board a plane and come to the United States. If you have an expired visa, they're not going to let you board the plane, right? But the visa does not guarantee you an admission in the US. That's your status. So having an expired visa in your passport doesn't necessarily mean you're unlawful here. You could still be in lawful status as long as for an F1, your CVIS record is updated and current and you have a new I-20. So expired visa does not mean you're illegally here. But next time you travel outside of the US, you will need a new visa or a renewed visa to come back in. So if you're an F1 and you're continuing your studies, but your F1 visa has expired, you have the option of remaining in the United States while you complete your studies. But if and when you have to travel overseas, you need to apply for a new visa in order to travel back in. So if you're an F1 student and you're still enrolled here, but your F1 visa expired, let's say June of this year, but you're planning to go to India, maybe during the winter break, Christmas holidays, now you will need a new visa to come back in because your expired visa is not going to let you come back in. And the wait times with all of these changes and the interview requirement is going to or could potentially delay your plans of coming back. So they're going to have to prepare and manage their trips accordingly.
Is there going to be a difference for people who are applying for a visa for the first time or people who are applying to renew that visa? Are they going to be treated the same under this process or are they going to be treated differently?
So to answer, it's a good question because the scrutiny at the counselors have become gatekeepers, right? They always are. They always have been gatekeepers, but their gatekeeping duties and responsibilities have become even more tough now. They always, anybody who's applying for a visa to come to the United States must establish their non-immigrant intent. Most visa denials, I'm sure you hear about it. Oh, so and so applied for a tourist visa, but they were denied. But so and so applied, they were able to get it. So visa issuance is to a large extent dependent on the strong ties the visa applicant can show to their home country and can establish to the satisfaction of the consular officer that the purpose of their intended visit to the United States is strictly temporary, that they will be here for that purpose and that purpose alone, that they have no intention of immigrating. What that means is permanently immigrating to the United States. And they have to establish that by a variety of documentation and evidence of strong ties to their home country. Most immigrants have to what we call demonstrate to the consular officer that they have a strictly non-immigrant intent. And most visa denials are issued under Section 214B of the Immigration and Nationality Act. That is a standard, visa denial, which means you were not able to show to the consular officer your non-immigrant intent, or you could not negate your immigrant intent. So to answer your question, that scrutiny, as it is for the initial visa applicants, is there already. Will that translate to higher scrutiny or increased scrutiny for visa renewals? Chances are yes. Otherwise, what is the purpose of having them come for an interview again? And also now they look at which was not there a part of the visa application or even maybe the interview questions earlier. Now social media checks have become and are becoming more and more a part of not only the visa issuance, but also subject to inspection at the port of entry when you come through a US airport. So the answer to your question is, and again, this is something one would, they haven't told us this, but one would assume, yes, it's going to be a stricter scrutiny and more documentation, and that also means more denials.
Right. Yeah, that's helpful to know. And, it's probably going to depend on the type of visa or, what stay you're seeking, right? Someone who's coming for a tourist visa who's only been here, let's say 6 months over the 10 years versus someone who repeatedly comes every year. It might just be different levels of ability to show ties to not be an immigrant. So it's really interesting that it's going to become much more fact specific and dependent on the person, it sounds like.
And not only fact specific, also case specific and also visa specific. There is different kind of documentation that a student has to have, different kind of documentation that an H-1B worker has to have, different kind of documentation and or information that a tourist visa applicant may have to provide. So there's differences in that. But bottom line is this: tighter checks at multiple points, at the consulate and at the ports of entry.
Right. Yeah. And you already mentioned that electronic searches, scrutiny of social media, that is on the rise, right? So the Trump administration boasted conducting over 3,000 electronic device searches within their first 100 days. And that seems to have continued as a pattern of heightened scrutiny of electronic searches. And what are we able to tell about the increases? Is it an increase in rate? Is it an increase in kind of the scrutiny of the types of things that they're posting? Is it more invasive and more thorough compared to what we were seeing in recent years?
I think it's all of the above. Definitely the tempo has increased. The number of searches have increased, not only for non-immigrant visa holders, but also I've heard for green card holders, and in some cases, even US citizens. So yes, it has also something what we call a secondary inspection that has also increased. Secondary inspection is something, or deferred inspection also. Secondary inspection is something when you come to an immigration, you come to the port of entry and you come before the CBP official, where you have to present your documents and the reason as to why you're visiting the US and all. And they ask you questions based on your responses to the answers to those questions. They may let you in, or they may put you through what is called a secondary inspection, which means you now have to go through another layer of inspection where you could be pulled aside and asked to wait in another area where some other CBP officials may question you more intrusively. They can go through your search through your devices. Apparently, what we know is that the device search is not just limited to non-immigrants. Even if you're a US citizen, your devices, your laptop, your phone, your iPad, whatever that you're carrying, is subject to be searched. So yeah, that has definitely increased. Yes.
Yes, it sounds like across the board, right? Mm-hmm. Device searches for any type of immigrant, non-immigrant, anyone at the border. It seems to be that you're at risk of that. And so the question everyone wants to know is, are there certain activities online or in person that seem to be getting more targeted for enforcement?
Absolutely. Yes. Your social media posts, your likes, your associations in any kind of organizations that are, for lack of, or your association may be viewed as what quote unquote sketchy, or what is not in the interest of the US government. Yes, any of those can make you. And then sometimes people don't post about what exactly is going on in my life or your life. You know what's going on in your life, and I know what I am doing in my personal life. Right? That may not be, but some people have been very vocal or at least open about posting their opinions, thinking the First Amendment rights are there for everybody. Well, then we can't just have rights, right? Sometimes those rights come with responsibilities, and sometimes even if it's not I'm not going to get into the discussion about responsible behavior versus not responsible behavior, or what my personal beliefs and opinions are. The simple thing is this: different immigration categories, different rule books. You want it to be straightforward, know the rules, adhere to the rules, follow the rules, and make sure your documentation and paperwork that you're required to present is up to date, is in order. And, your personal conduct at the time, whether you're appearing for an interview at the consulate or whether you're being questioned at the port of entry, will also count towards something. Your body language, the non-verbals, all of that, the CBP official is going to take it into consideration. Has that increased? For sure.
Yeah, it sounds like you're saying that scrutiny of, the physical presence of any documents, of your electronic devices, but also your activity online, all of that is very subject to scrutiny, and heightened scrutiny in the current time.
Yeah, that is correct.
That's very helpful to know. And I think that people appreciate knowing that that's not a rumor, right? Versus what are rumors and what isn't a rumor. The increased scrutiny is there. And so you have to decide what risks you're willing to take or not take.
Correct. And the simple thing is this: it's not necessarily all these rules are being rewritten. They have been there for some time, some of them. But the way they are being used right now or enforced, that has certainly shifted, for sure.
Yeah. And one of the things that we talked about is that there is constant change in some of the enforcement mechanisms. There is change in some of the rules. And one of the big areas that we're seeing a focus right now is H-1B visas. And many in the Indian and Hindu communities travel to the US on H-1B visas. One of the big things that we're seeing is that this year there were decreases in both unique beneficiary submissions and overall registrations of H-1B visas. And under the Trump administration, it seems like the focus is on significant changes to that process. I know that there were some proposed rules. I know that there are rumors of more changes coming. So what can you tell us about the changes that have actually already been announced and implemented to the H-1B process?
Okay, so what we know now is, or what rather I should say, what we have seen so far. Here are the few changes that started going into effect right away. And that was, some of them were already put in place with the past administration, but were implemented this season onward, is the H-1B cap season, or the H-1B lottery that is conducted every year. So the H-1B lottery that was conducted this year was for the fiscal year 2026 cap season. As I'm sure you and your audience would know, there are a finite number of H-1B visas that are issued every year that the USCIS conducts what they call a lottery, or is called an H-1B electronic registration system process. It's conducted typically in February or March every year. So one of the first changes that we started seeing this year onwards for the lottery that was held in March of this year was they switched from the electronic fee that they would charge for the last, I think it started in 2020 is what I'm trying to remember. Yeah, 2020 onwards, this system has been in place. It was like a $10 fee that they would charge. This was just to enter your number in the lottery. Now that has gone to 215 or some such thing. I'm not talking about the H-1B fees that the employer has to pay. That's in thousands and thousands of dollars. That is different. I'm talking about just to enter, like the lottery ticket that you have to buy kind of thing. So that was one of the changes that jumped from $10 to $215. The other rule that was issued and went into effect in January of 2025 was something called the H-1B modernization rule, which clarified the specialty occupation criteria, and it also expanded the site visit authority, including where H-1B workers were working at third-party or remote work sites. So what that translates into is more compliance checks, both for H-1B employers and for the H-1B employees. Now, the other change that happened this year was for the fiscal year 2026 lottery, USCIS selected enough people in the first draw, which was conducted in March. And for the first time since 2020, they announced that there is going to be no second lottery round in July. Typically, the first round is conducted in March, and then we have a 90-day period starting from April 1st to June 30th, during which those H-1B petitions are filed. Now, what happens every year, at least it has been happening since 2020, is not all candidates who are selected in the first round actually get an H-1B petition filed on their behalf for various reasons. And typically, the last few years, USCIS would conduct a second round sometime in July, and then a fewer number of applicants could then be picked up who could then apply in the second round for the H-1B. This year, they did not conduct a second round of lottery. So that was another big change we saw. Others changes that we are seeing, requests for evidence, which is even when you are filing an H-1B extension for somebody who's already here and have provided all of the documentation that is related to the job, to the employer, et cetera, the number of RFPs have just increased. They are onerous. They are a lot more documentation that they are requiring, and the site visits have also increased. But that again goes back to the modernization, H-1B modernization rule. Now, here's what is the other changes that we are seeing. The compliance pressure that is on the employers is definitely increasing. I personally have not seen this in my practice, although the large majority of my practice is business and employment-based and family immigration. But I have heard or read posts by other attorneys, colleagues who are saying that if they are representing a client who's in H-1B status but was laid off or terminated, they usually get a 60-day grace period during which they can change their employers. Another employer can file an H-1B transfer on their behalf. What they are saying is some of these H-1B employees are getting issued what is called an NTA, notice to appear. I have not heard of that before, but apparently it has been done that if, let's say I'm an H-1B employee and I'm working for employer A and I get laid off, and now I have a 60-day period during which I have to find another employer to file an H-1B on my behalf. And employer B, I found an employer B who is going to file a petition on my behalf, but while I am in that 60-day period, employer A has informed USCIS that and the Department of Labor that my employment has been terminated. An H-1B status is strictly employer specific. So the termination of employment means my status is now gone, but during that 60-day period, I'm still okay to stay here and look for another employer. But now there are reports that USCIS is now issuing notice to appear to these H-1B employees, even though they are in the process of filing for an H-1B transfer. So the bottom line is things have changed in the H-1B landscape greatly. But right before we got on this podcast, just a couple of hours ago, today being September 19th, another headlines has just come that the administration is going to add $100,000 fee for H-1B visas, for H-1B petitions. I do not even know what to make of this because I'll be honest, right now, the whole of the lawyers community, my brethren, my fraternity, we don't know what to make of this. It has not yet been announced. It may have been announced since we went on air. What's going to come of it? What are they announcing? What will it mean? Yet to be seen. Bottom line, things are changing faster than we can make sense of them.
Yeah, that seems to be the theme of today. Things are changing in actual rules. Things are changing, like in the legal processes, but then there's also kind of the soft mechanisms of enforcement that are changing along with that. And it's very hard to keep up with those changes because some of them, we can only read some of them, right? We can read the executive orders that come out. We can read the policy memos that come out, but we can't fully understand kind of the behind the scenes enforcement. We only have the information on what people say or report.
Correct.
That's kind of, that's the land that we're in immigration in this administration. So one other aspect of H-1Bs that is important and interesting is that over 75% of H-1B visas seem to go to Indian nationals. Mm-hmm. And do we have any sense of how any changes that have gone into effect or we think are going into effect might impact those numbers and those opportunities for employment-based visas?
Well, like I said, all these changes that have already taken place in H-1Bs are there already. The job market also is not the same right now as it was maybe last year or a couple of years ago. Things have changed. So that has definitely not just the immigration policies or changes that are impacting H-1B workers. The job market is also, the real-time employment situation is also having an impact on that. But the main H-1B users definitely are still coming from India. And for most Indians, H-1B and the F-1 is still the main legal gateway, I should say, to the United States. But the path is definitely narrower. It's way more expensive. It's way more closely monitored. And now with this latest announcement that just came out today, I can't even begin. I can't fathom what implications is it going to have on the H-1B program. What I can tell you is this, without sounding, the H-1B program is very outdated. I'm an immigrant myself. I have gone through the H-1B, H-4, green card route. So, I represent clients to go through that. But the fact of the matter is, H-1B system does need an update, for sure. So, how it's going to be updated, the manner in which it's going to be updated, we are going to find out. Right now, all it has become is more and more and more restrictive. Are they going to come out with a new system of having professionals work in some kind of visa categories? I don't know. Remains to be seen.
Yeah, that's just one type of visa. That's one aspect, right? Because another concern and another pathway that a lot of our listeners are going to care about is another pathway that a lot of our listeners will care about is the naturalization process, right? And that's getting your green card and hoping to get U.S. citizenship, a process that's managed by USCIS that you talked about previously. So it seems like there are major changes in that area as well. And it seems like USCIS is making significant changes to the factors considered during the naturalization process before you get U.S. citizenship. Mm-hmm. Can you talk a little bit about the factors that are being considered in that process? Specifically, I know one change is how they consider good moral character and how that's changed.
Yes, so that's actually correct. Some of the most significant changes that immigration policy changes that have come about recently are in the naturalization system. So in August, there were a few memos that were issued by USCIS. One of them that you referred to just now. It's actually, the title is Restoring a Rigorous, Holistic, and Comprehensive Good Moral Character Evaluation Standard. So in the last 27 plus years that I've been doing immigration, the naturalization application used to be just a couple of pages to now, I don't even know, 26, I don't know how many pages long, it's a long, long application. A lot of a lot of pages of those application are just yes and no questions, question after question after question that you basically have to check yes or no. And they are under different categories. One of them is good moral character. So the good moral character evaluation standard is not something new. That has been there for a long, long time. They were really not enforcing it. Basically, what it was, I take that back. They were enforcing it, but basically, the information that the applicant provided on the form itself by checking those yes or no boxes would generally be considered sufficient. Now, with the new policy memo, what they are doing is they are USCIS adjudications officers are going to be looking for the applicant to provide them information and or documents to show their good moral character. So the GMC bar has just become higher. They are expected to demonstrate positive ties to their community. You're going to be judged by anything that may be considered a disqualification. So not only it's just the standard of good moral character has increased, USCIS also issued another memo which says they're going to be reinstating neighborhood checks and personal investigations. So these two memos are going to be taken in tandem. So those neighborhood checks have been a practice that is there, but USCIS for the last, I don't know, 35 years or so really has not been implementing it. Now now that they're saying is officers are going to decide on a case-to-case basis whether they're going to do an investigation. What that means is they can actually conduct interviews with your neighbors, your coworkers, your employers, or anyone that may have any knowledge about the applicant. So what that means is, why are they saying that they're going to do these checks? They want to be able to validate that you are continuously residing where you say you are maintaining a residence. You have a good moral character and you have ties. Basically, how have you lived your life in the United States? Are you a good citizen? Prove it to us. So if you are someone who has not yet filed an application or you are planning to file a naturalization application anytime soon, keep in mind the naturalization process is moving from just filling out forms or a checklist of documents. It's now going to be a test of your character. It's no longer going to be just the answers you provide to the yes or no questions. USCIS officers are now going to not only look at what you have not done, meaning you've not had any traffic violations, you've not gotten into trouble with any law enforcement agencies and none of that, but they're also going to look at what have you contributed to the society, to the community you live in, to your workplace. How do other people view you? So that has definitely is a big, big change. And also 2 days ago, on September 17th, they announced yet another change in the naturalization process, which is a new set of questions for the civics exam. Anybody who applies for naturalization has to pass their test in English proficiency and their knowledge of US civics and history. So those questions, or that civics test, is going to be changed. It was announced 2 days ago. It goes into effect on October 20th, 2025. it's going to be a larger bank of 128 questions that you have to prepare from, instead of the 100 that used to be there before. Under the previous test, the immigration officer would ask you 10 questions, and as long as you answered 6 of them correctly, you would pass the test. Now you're going to be asked 20 questions. You must answer at least 12 of them correctly. So all of these recent changes in the naturalization process is going to definitely impact the Indian American community, because Indian American community is one of the largest communities who files for naturalization. And the key thing for them, for anybody who's applying for this, is make sure you are keeping, or at least if not keeping, taking the time to get more involved with your community. You are prepared to present evidence or documentation of any kind of work that you do, volunteer, make sure you have extensive records of all of your taxes. If you have any kind of child support or alimony payments that don't be a deadbeat, make sure you have all of them, up to date. All of that's going to help. Keep that evidence ready. That's going to make a difference. Exams going to be tougher. If you're going to be filing after October 20th, make sure you have more time to study, more preparation, and basically just follow the rules. The best I can tell you.
It sounds like the process in all of these visa categories, the naturalization process, it sounds like everything is a little bit more rigorous.
Exactly. Basically, USCIS wants to make sure nothing bad shows up in your background, and that's just not where it stops. They want you to provide them the good stuff: who you are, what you have done in your community, what are you doing in your community, whether you're keeping up with your ties, your social behavior. It's more of a review of how you live your life in the US. Basically, that's what it comes down to.
And it sounds like that can go either way, right? Mm-hmm. Your helpful factors of the good things you do are helpful, and they will be considered, but so will some of the stuff that you have done that may not shed a great light on you. So it sounds like everyone should expect more scrutiny throughout the process. And the other thing about the changes to the civics test I noticed is, even in the title of that, it says it's step 1 in a multi-factor overhaul of those standards. So I think it's safe to say that we expect more changes to that process as well.
I think that's safe to say, correct, to echo you. Yes,
right.
That is correct.
And then now we get to the topic that is very frequently on people's minds and also very much in the news. And that's deportation, which you clarified, right? You're talking about the removal process, but it's colloquially, everyone talks about deportation. Mm-hmm. And that's really just kind of the final enforcement mechanism, and ICE going in to say your time's up. All right. So I think we are going to end on another topic that was headlines from the beginning of the administration, and that was planes of people who were unauthorized immigrants being sent back to India. Given that India actually has one of the biggest populations of unauthorized immigrants that are in the US, are people coming here from India facing increased scrutiny?
So, yes. India does rank high on the list of countries with unauthorized immigrants in the US. A lot of people from India who are now unlawfully present here, it's a term we use, they are people who came legally on visas, but then they overstayed or didn't go back. It also includes a large number of people who have traveled through, unfortunately, what is called the donkey route. That's a colloquial word that they use for donkey, but basically it means where you pay smugglers to move through different countries before reaching the US-Mexico border, a risky, expensive way, which often leaves people vulnerable to fraud or danger along the way. So those numbers have definitely increased over the last 10 to 15 years. And I will say, especially in the last 5 years, there has been a sharp rise in the number of Indians arriving without papers, without proper visas at the US Mexico border. And these cases have now become more visible. They unfortunately are also shaping the perception of the risk, quote unquote, of Indian immigration, the perception in the general mainstream, public view, opinion. So, having said that, I will say most Indian nationals still come through the legal pathways, F1 visas, student visas, H1Bs, or through family immigration or L1 workers. But because India also shows up in the statistics about overstays and in the increased number of what they call illegal crossings, this has led to Indian visa applicants facing tougher interviews, more checks, both abroad and also at the consulate.
Yeah.
So go ahead. Sorry.
No.
No, what I was going to say is, unfortunately, we don't like to talk about it much. We in the Indian American community, because I will go ahead and say this, because it doesn't fit the dominant image of the Indian community in the US, at least in our eyes, right? Because the large thing that we like to say or think about ourselves is we do things the legal way. Most of our community is through legal immigration, through education, through employment, business, or family. And so people are reluctant to talk about migration from India that falls outside of that narrative, because it, for various reasons, maybe we think it falls, or rather, it reflects poorly on our image of the model Indian immigrant community. But these migrant stories are also a part of it. They are a part of the Indian immigrant fabric.
And what's interesting is that both Malawi and Zambia are countries that the US has identified based on their visa overstay rates. And so people traveling from passports on those countries are now required to post a bond of between $5,000 to $15,000, and that started in August. Now, India's not on that list, but it sounds like you're saying there's increased scrutiny, and who knows where that list has started and where it will end.
Yeah, I do not know about that, whether India is going to be on that list or not. But what definitely their scrutiny is there, and I think it was last month in August there was this accident in Florida, where a truck driver from India was driving a truck, and I think he made an unauthorized U-turn or something, some traffic violation, as a result of which it caused an accident in which 3 people died. And now this truck driver had a valid commercial driver's license. And there's a lot of talk in the news media or on social media, if you go about it, as to how was he able to get a CDL. Now, I'm not his attorney. I have no idea how it went, but I have a fairly good sense of how it typically works, because most of the people, especially in the last 5 years, who have been coming, I'm talking again about India, because right now we're talking about, migration at the southern border from India, they are allowed to come in and apply for asylum, because that's typically what they fight for. Why? Because the smuggling networks often sell them the dream of asylum. Because asylum, once you file for asylum, you can then get your work permit. With a work permit, you can get a driver's license, in this case, a commercial driver's license with which you can drive a truck. But I think in this case, it came out that the driver was this particular gentleman, even though he had a valid license, probably couldn't read English properly or understand the signs properly. And that's why his traffic violation or driving violation ended up in, unfortunately, the loss of 3 lives. But anyway, that's a different discussion. But asylum is what they are coming and filing for. So that is, it's something that is coming out more and more in the media and also on social media, which does change the perception of Indian immigration in the US, for sure. Yes.
Right. And I think that in general, whether it's that incident with the truck driver, whether it's a lot of scrutiny on H-1B workers, it seems that Indian immigration is facing a lot of scrutiny, sometimes backlash, because there's a large community coming in. Like you said, there are a lot of them in the process of becoming naturalized citizens. There are a lot of them using the H-1B visa path to do temporary immigration. So the last part of that is the unauthorized immigrants and removal proceedings. Are we seeing the community being targeted for enforcement given the number of visa overstayers or people who are coming in the unauthorized route?
Well, as you said, earlier in the year, there were these military planes that deported people to India. I think the flights went to Amritsar, but not all of the people who were deported were from Punjab. They were people from Gujarat, from Haryana, from UP, from Rajasthan, from other states, because the smuggling networks have become so strong and widespread in India. So what they were doing, or what they did with these deportations earlier in the year, were I think they were deporting the more recent arrivals right away. But there are people who have already been here for the last few years, who are already in the court system, in the immigration court system, and are going through their removal process. As and when their case, so we haven't talked about this, but not only have things changed in USCIS immigration, they've also changed in the Department of Justice. The Department of Justice has jurisdiction over all of the immigration courts. The Department of Justice has a branch called EOIR, Executive Office of Immigration Reform. EOIR oversees all of the immigration courts and immigration judges in the entire country. So there are lots of changes that have happened in the EOIR, or the immigration court system process. So more of these cases are going to be denied. And once you have a final order of removal, you will be deported. So it's, yes, that will also increase. But for the Indian community, the key thing to remember is this. If you're here lawfully on a visa, or if you have a green card, or if you have a pending asylum application, the system for the ones in immigration proceedings or removal proceedings, the systems will still require court review before you're deported. Remember, most deportations often involve people without status, or it includes those who entered without proper documentation. The forms of relief that they file for, whether it is asylum or withholding of removal, it's going into different categories. With one, you can do certain things, with the other, you cannot. Deportations are not new, but the high visibility operations like the military flights that happened earlier, they do shape how enforcement feels for our community, and especially for the Indian families who are not here but watching from afar. It does make a difference. Absolutely.
Yeah, that's really helpful to know. And I think that's a great place to end this conversation. This conversation has made clear that there are a few things we know about the immigration policies and how they've changed. But we know for sure that immigration is such a hot topic and that it's an area of significant activity under this current administration. So we can expect the changes to continue. Thank you, Akanksha, so much for sharing your insights and your knowledge. It's been great to have you.
Thank you very much for having me on your podcast. I will leave you with one thing. Basically, if you zoom out of this, one pattern is clear. Immigration rules are getting tighter. The stakes for small mistakes are higher. And we in the Indian American community do feel the shift more, because we are so deeply tied to every stage. The F1s, the H1s, the families in limbo waiting for their green cards, the large number of Indian Americans who naturalize each year. So all of these policy changes hit the community harder. But I will say one thing, these rules matter. The knowledge of these rules and these changes matter. So I thank you and HAF for creating this space, because by sharing knowledge and experience, hopefully we can get some clarity.
Well, that's it for this episode of That's So Hindu. If you enjoyed this episode, please share it now with someone who you think will like it too. Please also like, follow, and or subscribe to this show on whatever platform you're listening to it on. You can help ensure that more of these get made by making a donation to HAF at www.indoamerican.org/donate. Thanks again for listening.